Thanks. You may be seated.
Good morning. We're here for oral argument in City of Surprise versus Circle City Water Company and Lake Pleasant 5000. It's our CV220532. As you know, the proceedings are both live streamed and taped. They'll be on the YouTube channel later. But in deference to that, will you please announce your name and the client you're representing when you approach the microphone? You each have 20 minutes aside. You are required for keeping your own time. It's displayed up here on the clock. And before you start, just know that we have reviewed the briefing, the record, and conferenced the case this morning before oral argument. So with that, you may proceed.
Thank you, and good morning, Your Honors. May it please the Court, Dale Zeitlin, and appearing on behalf of Lake Pleasant 5000, the Mom family, and Harvard Investments. I'll refer to the three of them probably as LP 5000, as we did in the brief. Very quickly, Your Honors, the issue here is actually a narrow one, and it turns on whether the parties have a enforceable contract, the Water Facilities Agreement, which we also call the WFA. To that, there is no dispute. The WFA, all parties agree, and as the Court found, is a binding agreement that required Circle City to deliver potable water to LP 5000. It was enforceable. It could not be assigned. It defined the land that had to be serviced, and that is the contract at stake that we believe has been taken. And we submit to Your Honor, that's really all this case is about.
Counsel, let me ask you, can you have, and I understand that you say it wasn't a conditional contract in
Correct.
that it's only the cap water that needed the signature of the federal government.
That's true.
Right. So but let's forget about the groundwater. Can a conditional contract be property that is condemned? There's a takings, a recognized takings under the Constitution of this
Yes,
state.
thank you, Your Honor. So I would say the answer to that is yes. However, I wouldn't necessarily, in fact, I wouldn't label this contract as conditional. And that's where I think the trial court got into trouble. I think what she said was that we have a binding contract, but we're going to call it I think she used a contract expectancy. Maybe that's what you mean also by conditional.
Right. Something, there's someone not in the room that will eventually need to be in the room in order to make it happen.
Right.
And here's the federal government here.
So two things. So first of all, this wasn't a contract expectancy, or as you might call it, a conditional contract, is enforceable, and that is enforceable property right. And let me just discuss that for a sec. So here we have a contract between the federal government and Circle City for delivery of water. That was in existence. It was, in fact, that's what the whole condemnation case is about. Surprise wants to take the water and displace LP 5000's rights to the water through its WFA. So let's assume, for example...
Well, isn't Surprise really wanting the rights to the water? And what your client wants is the right to have that water delivered. So because Surprise is actually going to be, asking for the federal government to bless it taking over, your client never was going to be contracting with the federal government to have a right to the cap water, where Surprise is going to try to do that if they have hopes of having the rights to the water. So your contract wasn't rights to water, it was rights to have water that someone else had a right to be delivered to the people who were eventually going to populate the land.
I totally agree. Totally agree with that. And that is a compensable property right under condemnation law. And let's assume that Circle City decided to abandon, before this, let's assume there's no condemnation, because that's what we really want to get to, is what's the real world without condemnation. Let's assume Circle City decides we want to abandon the federal
We
contract.
don't want to,
We don't want the water.
abandon the federal contract or abandon the right to deliver water to you?
No, okay, first, I'm just going, let's assume they want to abandon the federal contract. They said, okay, we don't want this federal contract anymore. So Harvard LP 5000 then would have a breach of contract claim against Circle City. Why is that? Because now Circle City is breaching their contractual agreement to deliver water to the 5,000 acres of development. That's the contract. That's why in every case where there's an existing contract, and there's no cases contrary to this, when there's this existing contract and we can enforce it through a breach, that's enforceable. What I think the conditional part, and again, I kind of quibble with that word because I don't think it's conditional at all. We had an absolute right to get water delivery. That's what we're claiming got taken. The fact is that Circle City could never get out of that right without breaching the contract. That obligation to deliver water. And that was protected twofold, Your Honors. That was protected by contract, and the contract's super clear. The Circle City can't assign that contract. They can't assign any obligations without LP 5000's consent. So Circle City just simply can't get out of their obligation to deliver water, period. That's what's protected. Second layer of protection, which is unusual, was we had regulatory protection from the ACC. And the ACC, in fact, before this condemnation case, the ACC determined on an application by Circle City that the LP 5000 development was viable and you have to service. There was no way. It was, and I don't say this lightly, it was impossible for Circle City to get out of their obligation. They were delivered a monopoly to service this area. They had the water, and this is one of the weird things about this case, is that Circle City is one of those few things that they had such a tiny service area before Harvard, they couldn't use the water. So they needed a source to use the water. They found it in Harvard, or LP 5000, to service the 5,000 acres. They knew the LP 5000 had a development approved for 8,500 homes.
Right, but isn't the question, I think the question that you two seem to be at odds with are whether that's the contract right, okay, but the taking, the actual, is the right to delivery, which you just said at the beginning in answer to my question, is
Yes.
what you claim is the taking.
Yes.
Is that different from the water itself?
No.
Okay, why not?
The reason is this, and really the court found, and this is, again, where we kind of got off base. It is not different because, and clearly the case was pled to carve out the WFA. Obviously we see that, which is super unusual in and of itself. But the answer is this. The taking by surprise of both the groundwater and, with assignment or approval from the feds, the federal water, the surface water, means, as the court found, and no one disputes this, that the WFA is impossible. In other words, that Circle City can't perform. The WFA has been rendered meaningless. And I just want to say on the impossibility issue, that's true in every condemnation case.
Right, but I'm trying to steer you back to the idea that it's impossible that they deliver water. You've agreed that the only thing you were owed under that contract was water delivery, but you're saying that is the delivery is a property right. And I'm saying, what's the difference between you were supposed to have possession of 30 gallons of water, just like the international paper case. We were supposed to get a certain number. That's not what you have. You had a right to have delivery of water. So what is the difference as far as property? Yes, one's property. No, the other one isn't, or they're both property rights. That's where you two go like this. The water itself is one thing. The idea that the delivery of the water was what your contract for, that's where we need to find that is property in order to get a taking. Or tell me why I'm wrong.
I think you're wrong, if I understand your question, and that's this. You can't have delivery without water. Once you can't divorce the two. And that's kind of the international paper case. You can't divorce the two.
Well, but you weren't guaranteed a certain number of gallons. You weren't guaranteed, you said you were going to have a need. They were saying we're going to deliver water to try to meet your needs. Here's the water supplies that will become a part of meeting that need. But you were not guaranteed in that contract this many acre feet, this many gallons, whatever.
Agreed.
You weren't guaranteed that piece of something that we would normally think of as property, as the mine, the sand and gravel at the mining place, the water in international paper. That's not this case, and so we're going to have to find that the delivery of the water is a property right that therefore has constitutional protections in a condemnation taking case. How do we do that?
What you have to find is that the only thing you really have to find, to be perfectly frank, is that there was a binding enforceable contract and to deliver water service, and water service can't be delivered. The rest of it's, frankly, that's the property. The rest of it's a valuation question. It's not a entitlement question. So when you ask, there wasn't a specific gallonage, we know that. That's a fair question. And I suggest to your honors, that's just completely irrelevant. And the reason it's irrelevant is because when the property gets developed, whatever the gallonage requirement is, Circle City had to deliver it. They had to deliver whatever that gallonage is, whether it was through groundwater or CAP water. It didn't make a difference, but they had to deliver it to service Harvard. They couldn't get out of that obligation. And I just want to say this, that's an argument that's been made, but when you really look at the WFA and you actually look at the water plan, the water master plan, section 5, it actually addresses this. And again, I agree, it doesn't give the exact gallonage, but it states that during peak hours, which is really in the morning, when you're taking showers and using the restroom, that the property needed both groundwater and surface water. So here's the thing. Why you didn't have to get into the gallonage? They took all of it. It's not like the city, surprise, carve out and say, well, we're going to keep a couple of thousand water gallons or acres of water to service LP 5000. We're going to honor that obligation. No, they took it all. They took it all. So this delivery cannot happen. Our right to water service is gone. It has been taken. So that is, I'm saying very honestly, that's the gist of the case. And it was clever pleading, perhaps, artful negotiation between Surprise and Circle City, but because the whole point was to loot the water from Circle City and get
What if the federal government says no, Surprise? Nope.
What's that?
What if the federal government does not bless this and allow Surprise to come into contract for that cap water?
Okay, sure. Then the condemnation case would certainly disappear, would certainly go away.
So is it too early for anybody to weigh in when we don't know if Surprise is actually going to get access to the cap water?
Well, I actually raised that issue, and I was in a motion to the court saying, this is premature, we don't know. And I also put it in the briefing. I'm saying, this is one of the weird things about this case, why I don't think it's directly on point for this appeal, but why I think the condemnation case is entirely a sham. And there's one thing that drives the condemnation, only one thing, and that's to get their hands on the CAP water. And that's the one thing that the condemnation case cannot deliver. They cannot get a vested right to CAP water through the condemnation. All they can get is an assignment approved by the federal government. And and why is that so important? And I just want to address it because, as you've seen, this is a crazy case that first went to the Supreme Court, and what I call a surgical strike to determine, very good lawyering, by the way, to determine this plain vanilla issue that the ACC doesn't have jurisdiction over condemnation. It's a pretty easy case to win in front of the Supreme Court. The Supreme Court says, yeah, of course. Justice Bolick had some reservations. But now we get to what really happens in the trial court, and we see that fundamentally it is a contract. And why is that important? Because the ACC has jurisdiction over contracts under ARS 40-285 to prevent the looting of a regulated utility. So I submit, and so the gist of this case is contract, even though it's clothed in condemnation. So let's assume I'm right. If we go back, and that gets back to the whole argument that we haven't even, that we weren't able to talk about public use and necessity. We go back to argue public use and necessity. One of the things we can argue is that the condemnation is brought in bad faith and sham, and we weren't allowed to even address it because we didn't have standing, although we were the only party harmed in this entire thing. So we clearly have standing. We go back and argue it. If we prevail on that argument, the condemnation case goes away, and guess what? We go back to the ACC, we go back to the WFA, and as I said all along, Circle City can't get out of delivering water service without breaching the contract. And the ACC will require them not to loot their company so that they can get out of delivering water. That's this case, Your Honor. And the remedy is just compensation. The remedy has nothing to do with impossibility and restitution. I mean, I'm going to reserve a little bit on that rebuttal, but if you read Circle City's brief, it's 50 pages long. There's not one case that they cite, and there's not one case in the country that supports a remedy in a condemnation case of restitution. Never, ever. And the reason is because every condemnation case creates impossibility of performance. That's a contract issue. Of course, if the condemnation case was real, Circle City can't perform. There's no contract claim there if the case is legit.
So counsel,
Yeah.
let's go back to the friendly condemnation. Is Arizona, is it the law in Arizona as a matter of law that a friendly condemnation can't be challenged or I guess based on collusion? Is that how do you read Bollock and that exchange?
No, I don't think that's the law.
And if that's not the law, then what kind of questions of fact would remain that you didn't have the opportunity to conduct discovery on?
Well, so the law is, I believe we'll get back into the public use and necessity, the argument that would be in front of the trial court on a hearing on public use and need. And that argument, the standard there is arbitrary, capricious, abuse of discretion, and bad faith or fraud. That's the standard. So what we would go back in and try to prove and take depositions, and I don't think it'd be very hard that this whole case is being brought in bad faith, and which is, I think it's almost right on the surface, but we'd want to take depositions and get to take the deposition of the water czar, in the city, and to make that determination. There's a lot of discovery we'd want to take on that, Your Honor, and we're precluded from doing anything, even, other than just signing our name to a counterclaim and cross-claim. So I'd like to, if you have no further questions, I would like to reserve, if possible. Okay, thank you.
May it please the Court, Bob Henry, Snell and Wilmer, on behalf of Appalachia, City of Surprise. I would like to reserve a couple minutes of our side's allotted time for Ms. Megan Grable, counsel for Appalachia, Circle City, also here at council table to address any issues you may have regarding the issues unique to Circle City, restitution, attorney's fees, and what else. I'd like to start with the question, or what I understood to be the question Your Honor was asking about, is the right to deliver water the same as water? And I heard Mr. Zeitlin concede that he, for this case, considers them one and the same. I deem that admission to be fundamentally fatal to their entire argument in this takings case. Primarily because they don't have any property rights to the water.
Will you move your microphone just a little bit?
Yeah.
Thank you.
Can you hear me better now?
Yeah.
Because they do not have any property rights to the water. They don't have any property rights to the water under the WFA itself. It expressly disclaims, in fact, that there was any guarantee of water service, regular water service. And even if there was some type of an effort to convey water rights in the WFA, the Maricopa-Stanfield case, which I was surprised did not even get mentioned in Mr. Zeitlin's argument, makes clear, the Arizona Supreme Court and the Ninth Circuit, for that matter, have made clear that because of the unique nature of water in the lower Colorado River, that these cases from other jurisdictions about water may be interesting, but it's a unique, distinctive nature here in Arizona with respect to the lower Colorado River. And that case stands on all squares with the proposition that a party in the shoes of the developer parties here has no vested rights, no property interest in the water. Yet that's the argument I just heard. If there is no property interest...
What about the groundwater?
Well, I'm glad you asked that, Your Honor. The groundwater, in full candor, first really came to a head in the reply on this appeal. It was mentioned in passing here and there throughout the briefing at below, but it was really never front and center. For that matter, Judge Contis did expressly find in her ruling that it was not just rights to cap water, but any water for that matter. And that's probably for the same reason. The Water Facilities Agreement didn't convey any water rights, whatever source they may be. But in any event, I would submit first and foremost that issue has been waived. It didn't come up in any direct fashion until the reply on appeal here. And in fact, on the robust Rule 12 briefing at the trial court level, at the index of record 136, the response to the motion to dismiss, quote, "It is LP 5000's vested right to be served with potable water using capped surface water that has been destroyed." That was the argument. That has been the argument until the reply. So to answer your question, that has not been really even fleshed out at any stage of these proceedings.
So let's say it hasn't been waived, and I'm not saying maybe it has. Is there a question of fact there that would get them past 12B?
I don't think so, Your Honor. And first and foremost, and that's because it's well established in Arizona, as I understand it, that no one owns groundwater. No one. It's only when it's been taken for beneficial use that there's some ownership or rights to it that start to arise.
Let me ask you this. Let's say Circle City had customers. Okay, let's say they served 20 houses. Okay. And then we have what happened, which is Surprise come in and they condemn the water company and their water rights. And they say, you know what, we're going to use, Surprise says, we're going to use this all for our own citizens, for our own residents. And then there are 20 people now without water who were former Circle City customers. Do they have a takings claim?
That's an interesting question. One, it hasn't come up. Two, my understanding is that after this condemnation, it is the intention to serve water to these former customers. And for that matter, even to the LP 5000 property. That's been lost in the shuffle. It was mentioned a couple times in passing. But it seems to be, there's this big dramatic argument at all times that we'll have no water. That's not true. They won't have water from Circle City through the Water Facilities Agreement. But there are other ways to get water, as developers can do all the time. But I hope I answered your question on groundwater.
If that's the case, then why did the City of Surprise accept out LP 5000 in their condemnation action? Why did they not want that contract at all?
Well, that's a factual record that hasn't been developed. The Water Facility Agreement was designed for this particular development working with Circle City via the ACC oversight. A municipality provides water in a different manner. You can't just transfer this water services agreement and use it for a municipality generally. It would have to be a different water services agreement for this development. But be that as it may, my understanding is that it would include the provision of water.
Can we talk about the standing issue for the public use? Especially in a case like this where it's a so-called friendly condemnation, if someone who's affected because they were carved out, because they're losing rights to something in the condemnation, doesn't have standing to question it, where would a party ever have standing outside of the parties who are condemning and being condemned, be able to stand up and question collusion, fraudulently entered condemnation, if not for a party who's being affected by the condemnation itself?
Well, the Arizona legislature has assessed and addressed that issue in 12-1120, where it provides who has standing to participate in condemnation proceedings, and it's to only, quote, persons having an interest in any of the property being condemned or in the damages for the taking. The legislature has assessed who should show up or who can show up in condemnation proceedings, and if there is no property interest, no compensable property interest of someone, there is no standing for that person to be participating.
So you're saying that if the ruling stands that the water delivery was not a property right, then that also forecloses them from questioning public necessity under the statute?
Correct, because
no property right, you win there, no property right, you win on standing on public use as well.
I submit that's the case because of what the statute provides.
Right.
But once you've been deemed to not have a property right, an interest in the
I was
proceedings,
just making sure I had your
you don't have standing to
framing correct.
participate.
Okay.
And also, are there any other questions on public use and necessity? I'm prepared largely to stand on the briefing for that. Public use, we think, is almost axiomatic in a case like this. A municipality trying to take water for use for its citizens.
Well, that might be axiomatic, to use your word. But what about the other point, which is you have a friendly condemnation in air quotes, and we want to pursue that?
Well, first, many condemnations ultimately do end up being friendly at some point in the proceedings, and the parties end up stipulating to a final order and judgment, which includes a stipulation to public use and necessity, and the court has to assess whether the stipulation is sufficient. And I think the court here inherently found that public use and necessity is present.
As a matter of law? Because it was friendly?
Well, I don't know.
There's no discovery, there's no facts.
Well, I would turn that almost around and say, what discovery does one need to establish the public use of a municipality's taking of a water utility to serve its citizens?
Right. Well, maybe that's a good question on reply. I think he started to answer that, which is that this is all just sort of being engineered, and there are ulterior motives or plans. I don't know. I would have to. That's certainly important, but to say as a matter of law, you can't challenge a friendly condemnation. Is that the law?
I believe it would be, because as the Supreme Court has already provided in this very case, that the fact that it's a friendly condemnation doesn't change it from being a condemnation.
Nobody can challenge it if it's friendly.
Well,
including those 20 people that were served by the water before the condemnation.
Unless they have a compensable interest in the taking, or the court sees that there's something deficient with the stipulation of the parties with compensable interest to the public use determination. So
that case is your only authority for, as a matter of law, you cannot challenge a friendly condemnation, the Bollock dissent case.
In fact, we did look, and when we put in our briefs, the one case from an appellate court in New York that expressed the East 13th Street case, that the nature of the condemnation as friendly does not, standing alone, give a third party standing to challenge public use. That was the East 13th Street
Unless
case.
they fall under the statute and they have a property interest that was impaired by the condemnation.
Correct.
Okay.
Correct.
And what was the posture in that case? Any discovery? In the East 13th case?
The East 13th Street case, I don't remember off the top of my head what the posture of that case was, but there was the allegation of third parties wanting to come in and challenge public use to what was deemed to be a friendly condemnation in that case. And that court found that the nature of it being friendly, which I submit, is similar to what the Arizona Supreme Court found in this case. The nature of it being friendly doesn't change it from being a condemnation. And indeed, at any given time, the city of Surprise could be doing this without their consent. In fact, that was expressly threatened, and it's in the record. I can get you the site if necessary. But that was the city of Surprise. They were going to take this, and as the courts here, it's better when people agree in otherwise hostile proceedings. But turning back to this notion that whether they have a protectable property interest, we submit that the WFA itself and the Maricopa Stanfield case dispose of that argument, at least with respect to the cap water on the latter. But even if one were to find a potential property interest here, which we submit there is none, but even if one were to find that there's a compensable property interest, one then has to assess whether there's been a compensable taking. And we submit that here there has been no compensable taking of the developer's interests, whatever they may be. Let's assess what the city's not taking. The city's not taking, of course, any of the developer's land, not taking any of the water rights that Circle City has conveyed to the developer parties, none. Any water rights that the developer parties have a vested right to.
Let me ask you about this. So I think, are you at 12.1114?
No, not the-
Okay, so 12.1114 says, this is the group of private property that can be taken.
Yeah.
Okay? Subsection 6 reads as follows. All classes of private property not enumerated, including property for use in water or water rights, taken for public use when taking is authorized by law. Why isn't this water rights under that section?
I believe it would be. What the city is condemning, and we need to be careful to keep our eye on whose rights they are, the city is condemning Circle City's rights to the water, in this case, via its subcontract with the Secretary of Interior.
So you would say I don't know what the acronym we're using, but the agreement, the W something something.
TF.
Right, WTF.
No.
WFA.
WFA.
Oh, I am so sorry.
That's why acronyms I don't like.
Yeah.
That's not water rights.
That's not what, Your Honor?
Quote, water rights, end quote. Under 12-1114 subsection 6.
Well, the city is not taking the WFA. It's expressly excluded it from the assets.
What we're struggling with is we have this piece of property. They bought it. It had limited value because it didn't have a right to water. They enter into this negotiation with a water company to provide delivery of water. This condemnation action extinguishes the obligation to deliver water. That puts them back at not getting any contract benefit. So how do we value, or how do we even look at, there's some value in it, but how do we, it's not a right to water, it's not a use in water. We're looking at the statute. How is it not one of those things? We're talking about water. So help us conceptualize what exactly they contracted for. They didn't contract for specific water. They contracted for delivery of water. It increased their property value. Aren't they diminished in value somehow? And why is that not compensable if they had some right to receive water?
Well, I submit, Your Honor, that it's not compensable, and in many condemnations, a lot of parties have expectations that are injured, and it starts with Omnia, which of course has been briefed exhaustively, but the other cases, Air Pegasus, Huntley, the Palmyra case, all talk about, and this is where I think the fundamental distinction is what it's all about water. That's the subject matter.
Yes.
Okay? And that's what that line of cases starting with Omnia stand for. If the subject matter of the contract has been thwarted, that's not a compensable taking as a matter of law. It's when the contract has been taken. And here, not only did the city carve out the WFA, there's nothing in the WFA will still exist intact, is the word many courts use. It still exists. They're not taking any rights under the WFA. They're not taking any obligations under the WFA. They're not touching the WFA. So what they're taking is what the courts in those other cases I cited refer to as the subject matter of the taking. And that's where the whole line of thinking from Omnia starts, including for consequential loss or injury resulting from lawful governmental action, in this case a condemnation, the law affords no remedy. If under any power a contract or other property is taken, the contract is taken for public use, the government is liable. But if injured or destroyed by lawful action without a taking, the government is not liable. And that's been fleshed out, as I said, in Air Pegasus 2, Huntley, and Palmyra, as just some of the leading cases for that proposition. The other cases where they do find a taking is when the government action is in fact taking the contract or amending the contract. That's not happening here. It's not happening here at all. And the cases allude to the fact that this is a consequence of condemnation. The line has to be drawn somewhere. Otherwise, if you take it to its logical extreme, it would apply all the way to zoning changes of any nature. Always government action will have some effect on property. But if it's a lawful exercise of the power of eminent domain, which we submit this is, and no property interests, no vested, recognized property interests of the aggrieved party are being taken, they don't have a cause of action for inverse condemnation or anything arising out of the taking by the condemning authority.
And your opponent started out by stating that this has to do with a contract and agreement, and you would rephrase that as this has to do with a property interest, and there is no property interest that is compensable in this circumstance.
That is exactly our position.
Okay, thank you.
I have a minute and a half left for anything that you may have for Ms. Grable. If you don't, I'll answer any other questions, and if you don't, as my predecessor counsel in that other case said, I'll...
Yeah, I was going to say, can you talk to us about an hour when we have that follow-up question we forgot to ask?
Absolutely.
No. Thank you.
Thank you, Your Honors.
Oh, I'm sorry. You have time.
Minute and 13.
Yeah.
Thank you. May it please the Court, Megan Grable from Osborne Maladon on behalf of Circle City Water Company, the other appellee. I will very quickly go through a couple of points. First of all, to Judge Weinsweig's earlier question, Circle City does have existing customers. It has 186 existing customers. And under Title IX, I'm sorry I don't have the statutory reference because it wasn't at issue in the briefing, the city is required to serve those customers with water. And if it doesn't, the Arizona Corporation Commission is permitted to allow another public service corporation to come in and fill its shoes. And so any existing customer would not be left, without water under the existing statutory regime. With respect to the issue of whether the delivery
What's
is...
Section 9? Section
It's
9?
Title IX. I don't
Title
have
IX.
the specific statutory
Okay, all right.
reference. The only issue that was raised with respect to restitution by Mr. Zeitlin was that Circle City has not raised any cases on whether or not restitution is compensable for condemnation damages. The whole idea of restitution originated from Judge Comtes, where she said the LP 5000 may be entitled to damages for breach of contract, and raised and that's how the issue was briefed, whether restitution should be a contract damage, and that's how the briefing has been made. The other thing I'd want to point out real quickly is please note the dramatic shift in legal theory with respect to restitution that the developer defendants made during this. At first, they said they were entitled to restitution because they conferred on Circle City the benefit of the cap water, which they contended was worth $15 million. We said, well, the WFA preceded the cap water, so they came back in reply and said, never mind, we were wrong. It was actually because we gave you that CCNN, and that's worth $15 million. I respectfully submit they can't have it both ways, and I know I'm over time.
Okay.
Thank you.
All right. Thank you.
Thank you, Your Honors. I think you've now heard that, according to Surprise and Circle City, Lake Pleasant 5000 has no constitutional rights under Article 2, Section 17. They had right to water service. They had a contract. Contract is now extinguished. There's no question about that. but we don't have any rights according, and that's really the gist of what the argument is by the city, that they've just written out the Constitution. So let's talk about the Constitution. The Constitution, Section 17, is self-executing. That's important because even when a government tries to take property, carve it out, we still have they can't get around the Constitution. Property owners are protected by the Constitution, self-executing. Number two, we have a binding contract, not in dispute. Council mentions a couple of cases, the Air Pegasus case in Palmyra. I invite you to read them, particularly as I think you know, the King case, which recently came out of the claims court, has just a fantastic discussion of takings law. Those two cases are really interesting because Air Pegasus, what happened, there was a lease that expired. There was no contract at stake in that claims court case. In Palmyra was a fishing license case. Licenses, as a matter of law, are not property. That's up there. That's how that got distinguished. We have a contract, and that contract is to water service. That water service has been completely destroyed. Another point is we are in a CCNN. We have no way to get water without
What about what Circle City's lawyer just told us, though? What about what Circle City's lawyer just told us, that you will be provided for?
No. I'm sorry, Your
And
Honor.
I'm
That's
asking
not
you
what
to
she
answer
said.
that.
She said the 186 homes will be provided for. We don't necessarily
Right,
dispute
sorry,
that.
yes.
But that's why they're taking those homes, even though that was the negative income. They were losing money, Circle City, but they're not taking us because they can kind of get around that. They don't have to statutorily provide water. Another point, lastly, public use and necessity. Under Article 2, Section 17, that is a judicial issue de novo. That's not even arbitrary and capricious. And I didn't touch on this, we get to try to prove in court that Circle City didn't even have a public use or need for this, Surprise didn't have a public use and need for the water. And the record is that they have never put any evidence in as to why they need this water at all. We get to prove it as a matter of law, as a judicial question de novo.
Thank you. Thank you for your arguments. We will take the matter under advisement and issue our decision in due course, and we'll stand at recess while we reset for our last argument.